then Mr. Vaughn's representation will be on the criminal matters. And if that coincides, then he can represent you to that whatever extent that he determines that his obligations as your criminal lawyer would involve. But there is a requirement under the statute that we conduct a hearing on the requirement of bond. So that hearing will be heard on March 31st at 1 o'clock.
Your Honor, the forfeiture bond was moved to the criminal side, so Lindsay York was taking care of both of them.
Yes, ma'am. And you didn't want Lindsay York. So I have
I don't need it.
Pardon?
Get anybody, because I can't do that by myself.
Well, that is the law in the state of Tennessee, that you're entitled to an appointed attorney to represent you on a criminal matter. If by constitution, you have the right to a criminal attorney. On a civil matter, which is the ARC's seizure of the animals and their bond request, that is not criminal in nature. That is civil in nature. And as a result, under the law, you do not have the right to have an attorney appointed for you in a civil matter. So we will conduct the hearing, and you, Mr. Vaughn, can be there at that point to assist you in any way that he feels that his office can do so without circumventing the limits of their representation. If you want to hire a lawyer on the civil matter, that is your choice.
I would rather have Lindsay back to have.
I understand that, but with what you said you wanted and what you said now that you wanted, you don't get to pick and choose, Ms. Seib. On just when I'm talking, it would be better if you would just stop talking. You don't get to pick and choose your lawyer when you're asking for appointed counsel. If you want Lindsay York to represent you, you can contact her and to make arrangements to hire her as your lawyer on the civil portion of this case, or the criminal case. But as far as appointing her, I'm of the opinion, and unless somebody shows me a law that I'm not aware of, that a civil litigation, is that correct? The ARCs?
Your Honor, a state versus utility that does address whether the statute is criminal or civil. And the ruling of that was that this is a pre-judgment criminal matter. Now there is not any clarification as far as if she is entitled to an attorney in that regard, but
Well,
there is.
it has been consolidated by an order of the General Sessions Court with a criminal case. So, Mr. Vaughn, you might want to look into that. But Mr. Vaughn will be here on the 31st. We will conduct that hearing, and your office will be entitled to determine whether or not you have one, a conflict at all, two, whether or not you can represent her on this bond requirement. So we'll have the hearing at 31st at 1 o'clock.
All right.
All right. Thank you.
Your Honor, will we be able to present the?
Yes.
Your phone will go all right there. Just follow that.
All right. So we have Mr. Clark. What is the case that you're in?
This is State versus Alejandro Hermosillo. Mr. Hermosillo, if you could come forward,
Well,
please.
this is not on today's document. Is that correct?
Correct, Your Honor. This is a case that's been pending in general sessions. We've agreed to bring this matter before the court, if the court will accept it today, by way of criminal information to enter a plea.
All right. What are we doing on criminal information?
Do you want to go ahead and swear on that?
Want me to recite the facts, Your Honor?
Yes.
State of Tennessee would prove that on or about July 29th, the defendant, Alejandro Hermosillo, along with a co-defendant, were traveling through Ashland City and were pulled over for speeding. Upon a probable cause search of the vehicle, the officers did find mushrooms, a Schedule I drug with intent to sell, marijuana of not more than 10 pounds, numerous vapes and THC cartridges with the intent to sell, large amounts of drug paraphernalia to include trays, bags, digital scales, grinders, and a large amount of cash totaling over $3,000, along with a firearm in possession during the commission of this offense, Your Honor.
Right.
Okay, and Your Honor, the agreement, you want to go ahead and announce the plea now?
Yes, go
Okay.
ahead.
Sorry. Count one, Mr. Hermosillo would be agreeing to plea to attempt to possess Schedule 1 for resale Class C felony, be sentenced to 3 years suspended to state probation with a $2,000 fine. Count two, he would plead guilty to possession of a Schedule 6 for resale Class E felony with 2 years suspended to state probation, concurrent with count one. Count three, he would plead guilty to attempt to possess a firearm during the commission of a dangerous felony, a Class E felony with a sentence of 2 years suspended to state probation. He would forfeit the weapon. Count three would be concurrent with counts 1 and 2. Count four, he would plead guilty to unlawful drug paraphernalia, be sentenced to 11 months, 29 days, suspended to state probation with a $150 fine. Count four would be consecutive to counts 1, 2, and 3.
All right. You want to hand up that document?
Yes, Your Honor. I didn't have probation.
All right, Mr. Hermosillo needs to come forward and raise his right hand. Raise your right hand and be placed under oath.
Yes.
Thank you. State your full name for the record.
So, yes, Your Honor.
Say the full name.
Oh, Alejandro Hermosillo.
Mr. Hermosillo, you're here today charged with a multi-count indictment. You've heard your lawyer go over what the indictment is. It's actually a criminal information. So I want to cover with you the rights that you have. Any person who is charged in a criminal case has the right for the grand jury of that county to determine whether or not there is sufficient probable cause for the matter to have charges formally brought into circuit court. You have the right to waive that step and have a criminal information indicating entered in this case. Is that what you wish to do?
Yes, Your Honor.
You talked this over with Mr. Clark, you and he discussed what the advantage to you is, and this is what you want to do. Is that
Yes,
correct?
Your Honor.
All right. Do you understand what you're charged with, and do you believe you and Mr. Clark have discussed it so that you fully understand what you're charged with and what the range of punishment you're facing is, as well as any possible defenses you might have?
Yes, Your Honor.
Well, it's indicated that you want, is this a guilty plea? Do you understand if that you're going to be pleading guilty? Do you understand you have a right to plead not guilty and to have a speedy and public trial by jury?
Yes, Your Honor.
Do you understand if you went to trial, you would have the right to have a lawyer, to have one appointed if you cannot afford your own?
Yes, sir.
You understand that if you went to trial, you would be presumed to be innocent until such time, if ever the state proved your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict would have to be unanimous before you could be convicted of anything.
Yes, Your Honor.
You understand that if you went to trial, you and Mr. Clark could confront and cross-examine all witnesses the state called to testify against you, and you could bring in your own witnesses by the use of a subpoena.
Yes, Your Honor.
Do you understand that if you would be presumed to be innocent at trial, you would not have to testify or prove anything, and no inference of guilt would arise because you did not testify at your own trial?
Yes, Your Honor.
Do you understand if you went to trial, you were found guilty, you could appeal the conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal?
Yes, Your Honor.
Do you understand that by entering this plea of guilty, you're waiving your right to that trial and to the appeal? All I'm going to do is approve what your lawyer's worked out.
Yes, Your Honor.
You understand that's going to result in some convictions, and those convictions are going to be on your record in the future to make more severe the punishment you receive if you're ever again convicted of a crime.
Yes, Your Honor.
You understand everything I've explained to you?
Yes, Your
Do
Honor.
you want to waive your right to a trial and to an appeal by entering this plea of guilty?
Yes, Your Honor.
You understand if you plead guilty, the court of the state may ask you questions about this offense, and if you answer those questions under oath on the record and in the presence of your lawyer, your answers could later be used against you in a prosecution for perjury if we discover that you are lying under oath.
Yes, Your Honor.
Is your decision to plead guilty today voluntary?
Yes, sir.
Anybody forcing you to do this against your will?
No, sir.
Do you understand I cannot accept your plea unless I'm satisfied that you are in fact guilty of this charge and that that there are facts to support it?
Yes, Your Honor.
Now, you've heard Mr. Hodgson read the criminal information. Are all of those facts true and correct?
Yes, Your Honor.
You want to put any other facts, Mr. Hodlin, on the record? All right. Are you satisfied with your attorney's services?
Yes, Your Honor.
Do you feel like Mr. Clark has done a good job of representing you competently?
Yes, Your Honor.
Mr. Clark, you know of any reason he should not enter this play?
No, Your Honor.
Then Alejandro Hermosillo, on your plea of guilty to count one, attempt to possess a Schedule I drug for resale. I'll find you guilty, sentence you to 3 years. Tennessee Department of Corrections, and we suspended the state probation. You're ordered to pay a $2,000 fine and cost. Count 2, found guilty, sentenced to 2 years, suspended to state probation. Count 3, you're found guilty of attempt to possess a firearm during a commission of a dangerous felony, sentenced to 2 years, Tennessee Department of Corrections. That will be suspended. The weapon is forfeited. Count 4, you're found guilty, sentenced to 11 months and 29 days in a county jail, ordered to pay a $150 fine. Count 4 is to run consecutively to counts 1, 2, and 3, and that will be for an effective 5-year sentence. And is that correct?
4 years.
4.
3.
If it's consecutive, count 1 was 3-year sentence, count 2 was 2-year sentence, count 3 was a
2 years.
2-year sentence. Count 4 is consecutive. Count 4 is the 1129. Okay, I'm sorry.
Yes, sir.
That's right, a 4-year sentence.
And it's all probation.
All right, that's the judgment of the court. He needs to see the
Thank you.
probation department. We have some inmates here, I think.
Sign right here that you're waiving your right to go before a grand jury.
You have the criminal information of signing.
You've already waived that waiver. It's just a. Thanks. Step up.
We have 2 female inmates. Let's bring up the first one. Maria Casso, is that correct? Maria Trinidad Casio.
I think that's Mario Cosio. That's,
Oh, Mario.
I think this is Mr. Lockhart's.
All right, so who
Case.
do we have?
One of them's mine.
Who,
I've got to show the dog.
all right, bring her up.
About 9,786.
All right, I've been handed a document. This is Shelley Knowles in docket number 1979686. Ms. Knowles has been indicated that you're going to enter a plea of guilty to aggravated assault, receive a sentence of 4 years, Tennessee Department of Corrections, suspended to supervised probation. If you violate your terms of probation, it would be a 100% service, meaning you have to serve every day of that 4 years. That's only if you violate your probation and go to prison. You must also have and complete a mental health evaluation and follow the recommendations from that evaluation and have no contact with Brian Hollingsworth. All right. Is that what everybody understands the agreement to be?
Yes, Your Honor.
All right. Ms. Knowles, raise your right hand. Let's place you under oath.
Yes.
State your full name for the record.
Shelley Jean Knowles.
Ms. Knowles, you've heard me go over what the agreement is, but have you seen or been shown a copy of the charges against you and gone over with Mr. Lockhart the range of punishment you're facing as well as any possible defenses you might have?
Yes, sir.
Well, it's indicated that you want to enter a plea to aggravated assault, then that would mean that the domestic assault is being dismissed. Is that correct? Count 2.
Yes, Your Honor.
All right. But do you understand you have a right to plead not guilty to all charges and to have a speedy and public trial by jury?
Yes, sir.
You understand you would have the right to have a lawyer and have one appointed if you could not afford for your own?
Yes, sir.
You understand that if you went to trial, you would have the right to plead not guilty and that you would be presumed to be innocent until such time if ever the state proved your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict would have to be unanimous before you could be convicted of anything.
Yes.
You understand that if you went to trial, you and Mr. Lockhart could confront and cross-examine all witnesses the state called to testify against you. You could bring in your own witnesses by using a subpoena.
Yes, sir.
You understand that you would be presumed to be innocent. You and your lawyer, you would not have to testify or prove anything, and no inference of guilt would arise because you did not testify at your own trial.
Yes, sir.
You understand that if you went to trial and you were found guilty, you could appeal that conviction and the sentence imposed to the Court of Criminal Appeals, have a lawyer appointed to help you with that appeal.
Yes, sir.
You understand that by entering this plea of guilty, you're waiving your right to a trial and to an appeal. All I'm going to do is approve what your lawyer has worked out with the state. You understand that?
Yes, sir.
You understand that's going to result in a conviction, and that conviction will be on your record in the future to make more severe the punishment you receive if you're ever again convicted of a crime.
Yes.
You understand everything I've explained to you?
Yes, sir.
Do you want to waive your right to a trial and to an appeal by entering this plea of guilty?
Yes, sir.
Is your decision to plead guilty today voluntary?
Yes.
Anybody forcing you to do this
No,
against
sir.
your will? Do you understand if you plead guilty, the state or the court may ask you questions about the offense, and if you answer the questions under oath on the record and in the presence of your lawyer, your answers could later be used against you in a prosecution for perjury if we find out you were lying under oath?
Yes.
Do you understand I cannot accept your plea unless I'm satisfied there is a factual basis for it and that you are in fact guilty?
Yes, sir.
And are you guilty of this aggravated assault? What did you do?
Yes, sir.
What'd you do?
What did I do?
Yes, ma'am. What did you do to commit an aggravated assault?
What did I do?
Yeah.
I put a knife to his
To his
private parts.
To-
Yes,
You
because
put a knife-
I did not.
This was someone you were.
didn't want to no, I had not. I didn't want to consent to sex with him.
Okay, so you put a knife to this individual's private parts.
Yeah, I
Wow.
told him to zip it.
Anything further from the state? Are you satisfied with your attorney services?
Yes, sir.
You believe Mr. Locker's done a good job of representing
Yes,
your
sir.
company? Mr. Locker, do you know of any reason she should not enter this plea?
I do not, Your Honor.
And Shelley Knowles in docket number 19786, upon your plea of guilty to aggravated assault, count 2 of domestic assault is dismissed as a part of the agreement. Court finds you guilty, sentences you to 4 years Tennessee Department of Corrections that will be suspended to supervised probation. And you, as stated, if you violate your probation and required to serve your time, it will be at 100% release eligibility. You must enroll in and complete a mental health evaluation and follow the treatment recommendations and have no contact with Brian Hollingsworth. She needs to see the probation.
Thank you, Your Honor.
Thank you.
Walk over there.
All right. Who's our next one?
Docket number 19695.
Judge, I represent Ms. Clark. That is going to be for plea.
All right.
So she's pleading to count 3 and count 4. Counts 1 and 2 are going to be dismissed in settlement. Count 3, the especially aggravated sexual exploitation of a minor. It's a B felony. That'll be 10 years to serve in the TDOC, credit for time served. And count 4, solicitation of a minor, C felony. 6 years to serve in the TDOC. Concurrent with count 3, she'll have pretrial jail credits from 12/13/24 to 3/10/26.
All right. Raise your right hand and let's place you under oath.
Yes.
State your full name for the record.
Melissa Jean Clark.
Ms. Clark, you've heard what your lawyer's gone over, but have you seen or been shown a copy of the charges so that you and he have discussed the range of punishment you're facing as well as any possible defenses you might have to the charges?
Yes.
Well, it's indicated that you want to enter a plea of no contest. What that simply means is that you're not going to admit you did anything wrong. But when the state tells me what their evidence would be at trial, you're not going to contest that. And as a result of that, I will use that evidence to find you guilty according to this agreement. Do you understand that?
Yes.
Do you understand, however, that you have a right to plead not guilty and to have a speedy and public trial by jury?
Yes.
Do you understand if you went to trial, you would have the right to have a lawyer and have one appointed, as I've done with a public defender?
Yes, sir.
Do you understand that if you went to trial, you'd be presumed to be innocent until such time, if ever the state proved your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict would have to be unanimous before you could be convicted of anything?
Yes, sir.
Do you understand that if you went to trial, you and Mr. Vaughn could confront and cross-examine every witness the state called to testify against you, and you could bring in your own witnesses by the use of a subpoena?
Yes, sir.
Do you understand that you would be presumed to be innocent? You would not have to testify or prove anything, and no inference of guilt would arise because you did not testify at your own trial?
Yes, sir.
Do you understand if you went to trial, you were found guilty, you could appeal that conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal?
Yes, sir.
You understand that by entering this plea, you're waiving your right to that trial until the appeal. All I'm going to do is approve what your lawyers worked out.
Yes,
You understand that that's going to result in convictions that will be on your record in the future to make sure that, or make more serious the crime, the punishment you'll receive if you're ever get convicted of a crime.
yes,
You understand that this is going to require you to serve a sentence in prison, and that is a 100% service, meaning that you will be required to serve 100% of this.
Well, it is 100%. She asked me if it was 85. I believe you get up to 15% of the pretrial.
Right, and she does get pretrial jail sentence.
Right.
All right. And I believe that's more than right at 18 months or more that she gets credit for. Do you understand everything I've explained to you?
yes,
Do you wish to waive your right to a trial by entering this plea of guilty?
yes,
I'm sorry, plea of no contest. Is your decision to plead no contest today voluntary?
yes.
Anybody forcing you to do this against your will?
No, sir.
Do you understand I cannot accept your plea unless I'm satisfied there is a factual basis for it and that you are in fact guilty of these charges?
Yes, sir.
And I want you to listen as the state tells me what their evidence would be if this case went to trial. You may want to put your microphone over there toward you or come to the podium. But
You ready, Your Honor?
you're ready.
Yes, Your Honor. In docket 19695 on September 9th of 2024, a minor victim who would be the biological daughter of the defendant came in for a forensic interview. She stated that she was laying in the bed with her mother, who was communicating with someone that they only knew as Boatman. And he had offered to give them money to film a video of the defendant and her biological daughter using a spatula to penetrate her vagina, meaning the victim penetrated the defendant's vagina with the spatula. This was recorded on Snapchat and sent to this Boatman individual, and she did believe that her mother did receive cash because they were behind on a phone bill. We do not have the actual video of the incident, but there is a recovered video wherein the minor victim and the defendant are discussing who's going to do what to who and why. And when the defendant sees that she's recording, it stops. Those would be the facts.
All right, Ms. Clark, I'm not asking that you agree with those facts, but you understand this, what the state's evidence would be if this case went to trial.
Yes.
You satisfied with your attorney's services?
Can I get that repeated? I didn't
Pardon?
hear you. I didn't hear you.
I'm sorry. Are you satisfied with your attorney's services?
Yes,
You feel like Mr. Bond has done a good job of representing you
Yes.
competently? Mr. Bond, do you know of any reason she should not enter this plea?
No.
Anything further from the state?
No, Your Honor.
Then Melissa Clark, in docket number 19695, upon your plea of guilty to, or plea of no contest rather, to count 3, sexual exploitation of a minor especially aggravated, I find you guilty, sentence you to 10 years in the Tennessee Department of Corrections. You'll be given credit for time served. Count 4, solicitation of a minor, you're sentenced to 6 years in Tennessee Department of Corrections. That will be concurrent with count 3 as well. She gets pre-sentence jail credits as set out on this document.
Thank you, Judge.
Mr. Fuso, what do you have?
Good morning, Judge. I represented Mr. Roy Mayo. He's on page 6 of your Honor's docket. There's 2 cases, 2023 CR 19423 and 19424. This is a matter we've rolled a couple times. Mr. Mayo's in custody. We have obtained the expert, Your Honor, approved for that, and we've had him review everything. We're still talking about that, but we finally, I feel like at least have made some headway with trying to resolve the case. And I've got some authority from my client for the first time, and we're asking the court to potentially allow us to move this one more time to either plea or set it. I know Your Honor's position when it comes to setting a case for trial, and so if Your Honor would allow it, again,
Just
he's
don't want to set it for trial if it's not going to go to trial. So are we talking about July 14th?
I think that would be best, and I don't think we'll need a trial date after having some discussions
I don't
today.
think so either, Your Honor.
All right, July 14th.
Thank you, Judge.
So we will not need Mr. Mayo brought from the jail, correct?
No, Your Honor, I met with him last night here at the jail, so I informed him what we'd be trying to do today.
All right,
Thank
thank you. Dave versus Timothy A. Baxter.
Judge, I represent Mr. Baxter. I'd say call that. He is here now. That needs a trial date. That needs a trial date.
All right, General Sylvia, does it matter what month? If you think it looks bad for you, you can imagine what it looks for me.
That's fair.
So is this a case that I need to hear? Or, I mean, I'm glad to give you a trial date for, if that's what I need to do.
Yes. Otherwise.
So we'll be looking, if it's not in July, then we're looking at November. Nope. November, that's right. Well, it's my wife's birthday, so I'm not available. 17th, 18th, 19th, and 20th are all trial dates.
I have a feeling this will probably be two. I think we can get it done in 2 days.
Right. So do you want to put it on the 17th and 18th? Do you want the 19th and 20th?
What day?
So the county judge trial, the next is the murder trial that I'm on. I don't think that's going to be the whole week, so I don't know if we've got to go into.
What about the 12th and 13th of November?
12 and 13.
Fifth and 6th of November, is that still goes for, you know? So is that,
Good.
all right, set for trial, the 12th and 13th of November. That means Mr. Baxter will go to trial or plead to the indictment and go to sentencing. State versus Andrew E. Fox.
Judge, represent Mr. Fox. I've got, I will request another status date. He and I have gotten on the same page back again. We can just have a July date for a final plea date.
General, you have any opposition?
No, Your Honor.
July 14th will be the last status date. It will be set for trial. If it's not resolved by an agreement, it'll be set for trial at that time.
Fair enough, Judge. I'm gonna get your card.
Dave versus Jerry Wayne Moore.
Waiting to bring him up.
Okay. They're waiting for you to bring him up. We need Mr. Moore brought up.
I've got Mr. Krantz here, Judge. That's for a bond revocation hearing. Other than that, that's all I've got available.
All right, well, let's do the bond revocation here. Jonathan Krantz.
Sorry. Well,
Subject Krantz. All right, this is the state's motion to revoke bond.
Yes, Your Honor.
You may call your first witness.
call Miss Leslie Anderson with A2I bonding.
You'll come around, please, ma'am. Step up into the witness stand and raise your right hand.
I do. Can you state your name for the record?
Leslie Anderson,
And where are you employed?
A2I Monitoring.
What is A2I monitoring?
We are a GPS monitoring company and currently the monitoring company for Cheatham County.
Do you have a contract with a Jonathan Krantz?
We do.
All right. Can you tell me what Mr. Krantz is charged with?
Yes, he was charged with a domestic assault in order to serve on our GPS monitor on January 15th, 2025.
What court ordered him to wear that monitor?
Well, it's a condition of his bond. So
And do you remember which court?
it would have been Cheatham County General Sessions.
So General Sessions ordered him to wear that. And remind me of that date one more time.
January 15th, 2025.
Okay. So can you tell me what the obligations of Mr. Krantz is as someone being monitored by your company?
Yes. Any of the bond conditions that are outlined, obviously are a condition of his program, along with the payment of the GPS monitor, keeping his contact information up to date with us, including his information. The victim that's involved in this case, he would not have been allowed to be around that person and any of the addresses that they gave. Those are the basics.
Okay. So as far as those conditions, was he presented with a contract?
He was,
Did he sign that contract?
he did.
All right. Which of those conditions is he currently not in compliance with?
He is not paying his GPS monitoring fees as requested.
All right. What has your company done so far to make sure that he can be notified and make this right?
Mr. Krantz gets a weekly email and or text from us that gives him his weekly balance along with his overall outstanding balance.
So how long has it been that he has not been able to pay?
His last payment was on February 1st, 2026.
Okay. So did he make any statements regarding paying the monitor?
He is not,
Has he made any efforts to pay on the monitor?
not since February 1st, 2026.
Okay. And is his address current?
Yes,
So he's still residing at the address that you have on file for him?
correct.
What about his phone number? Is his phone number current?
Yes, I texted him and he responded today.
Okay. Has he had any other violations?
Not that I'm aware of.
And what is his current balance?
$1,305.92.
I have no other questions, Your Honor.
Well, you have any questions?
I do. Just a couple, ma'am. His name's Stefano. I represent Mr. Krantz. Do you have a copy of this contract?
I do.
May I see it? And what does Mr. Krantz's payment history look like?
I did bring his statement today. Early on in 2025, Mr. Krantz was making a weekly payment. So in the beginning, we made an agreement that he would pay $56 a week, each and every week. That the email and text are sent out on Friday, and he has a link to pay at his pleasure. He was doing that pretty rarely. And then after that, he just kind of fell off to once a month, about $56 once a month.
Okay.
And that's how his balance has accrued to what it is today.
Is deviating from the weekly payment to a monthly payment.
Yeah.
And you say the agreement was $56 a week? Okay,
It's $8 a day for every day that they're on. So that's 56 a week.
okay. That's all I have.
Redirect.
No, Your Honor.
Thank you, ma'am. You may sit down. Sylvia, you have any other witnesses?
No, Your Honor.
All right. Do you have any other proof you wish to offer?
No, Your Honor.
Vaughn? Thank you. Raise your right hand and let's place you under oath.
You state your name and spell your last name for the record, sir.
Jonathan Kane Krantz, Krantz.
And Mr. Kranz, I just want to remind you just overall with the, with the cases still pending, let's not discuss any matters of that, just strictly the ankle monitor you've got, okay? So you heard Ms. Anderson discuss that you all had gotten on a kind of a payment plan of $56 a week. Is that what you believe too?
Yes, sir.
And then this, and you've been successfully having it without violations, according to Ms. Anderson, for about over a year.
I've been on an ankle monitor since 2024.
Yeah.
September 24. Yes, sir.
So, and there's not really been any other issues, as she said. And then she's indicated that you're now at a $56 a month. What is there a reason for that? Like, what's happened?
I lost everything I own. I was kicked out of my house. Bank accounts drained.
And that was while you were incarcerated, correct?
That is correct.
And so how did you lose your home?
White collar crime. My house was broken into. Some paperwork was stolen, and they used it to put my house in their name.
All right. So where you live now?
Nowhere.
Nowhere?
Nowhere. No, sir. I have all my stuff in a garage, but I still wasn't able to move everything.
What do you do for work, Mr. Grant?
I'm a mechanic.
Okay. And how is business?
Considering my transmission went out right after I lost my house and truck and had to move, but it's pretty rough, but I'm trying to do what I can.
Okay. And so how are you getting money? Just side jobs and that kind of thing?
Mechanicing.
Mechanicing?
Yes.
Okay. Any particular shop? Or you just
no, sir, just mobile.
Mobile showing
Yes.
up. Got it. Do you think you'll be able to catch back up on this relatively soon?
Yes, sir. It's just been real rough the past month. Like I said, I've got like 500 I can pound it right now, and then the guy should be able to get caught back up as long as nothing else, happens.
Okay. So you would make a $500 payment today?
I'll pay more than that if I have it.
Okay, I'll pass.
So you lost everything while you were incarcerated. What were the dates that you were incarcerated?
Ma'am, I couldn't honestly tell you. I don't remember. I don't. It's trying to think. I don't know. It would have been December of 2024, all of it. Some in February,
February of what year?
2025. That was that. That's it. Yeah, that's when I lost it. Yeah, that's when I lost it. That was February 2025.
Okay. So you lost everything in February of 2025.
Yes, ma'am.
So do you live at 1001 Carl Perry Road?
No, ma'am.
Is that the address that you've given the monitoring company on your contract?
It is.
Is that the address that you've given the court?
Yes, ma'am.
But you don't live there?
No, ma'am.
And have you updated that?
I have no way to update it. I live in a truck.
Okay. And do you remember signing the contract to go onto the monitoring company? Go onto the monitor?
I believe it is. Yes, ma'am.
Okay. And was that following your incarceration? These
I
dates?
think it was before. I don't know.
Okay. So how were you able to make payments then?
Excuse me.
Well, we have a good payment history, and your testimony is that you lost everything while you were incarcerated. So how were you able to make payments all the way up until?
Because I had a home and I wasn't being forced to move, and my vehicle wasn't broken down, and everything could go wrong kind of went wrong.
Okay.
Yeah.
So I'm sorry, your testimony is kind of moving around on me. When did you become homeless? If you lost everything when you were incarcerated, but you were able to make payments for a year because you had a
I lost
home.
everything in February, and I was forced to move in, I believe, November.
November of 2025?
Yes.
Okay. So how were you able to make payments after November of 2025?
Because I still had some money.
Okay. And then how were you able to make bond?
I believe I was released without bond. I think it was my own signature.
Okay, so you had an OR bond.
I believe that's what they call it. Yes, ma'am.
And did you understand that it was going to be a requirement of your bond that you wear a monitor?
Yes, yes, state law, I believe.
Okay, and you understood that you were going to have to make payments on that monitor?
Yes, ma'am.
And what was your understanding if you were unable to make payments?
I wasn't ever told.
Okay, so if you understood that in order for you to be on bond, do you know what bond is?
Yes, I mean, yeah,
What is bond?
not in jail,
Not in jail.
Mhm.
All right, and there's requirements to not be in jail.
I suppose.
All right, so if you're unable to meet a requirement to not be in jail,
Mhm.
what do you suppose the outcome of not meeting that is?
I mean, I guess it depends on what the requirement is.
Okay, and if the requirement is to wear and pay for a monitor,
Well, you'd have to wear and pay for the monitor.
and if you couldn't wear and pay a monitor, what would you be doing?
Not wearing and paying them. I mean, I'd still be wearing it, but
Right. Would you be walking around or would you be required to go back to jail?
I do believe that depends on what county you're in, because multiple counties have determined that if the person does not have the ability to pay for the ankle monitor, that it comes out of general fund now.
Okay. When you signed an order agreeing to leave jail,
Yes.
did you agree to wear an ankle monitor?
I did not have a choice, but yes, ma'am, I did.
Okay. Well, the other choice was you could stay where?
Stay in jail.
All right. Okay. So we agreed, I'm not going to be in jail, but I'm going to wear an ankle monitor.
Yes.
And if you couldn't pay for the ankle monitor and you couldn't wear it, where did you think you would reside? Did you think you would go back to jail?
I was unaware that the payment part would send me back to jail, but
Okay.
Yeah.
So there's all these conditions to be on bond and not be in jail, right?
I suppose don't go anywhere she is, and
Pay the ankle monitor, no new arrest, all those things you agreed to being on bond.
I believe yes, ma'am.
Is this the only one that you think doesn't require you to go back to jail?
What do you mean? I didn't say anything doesn't require me to go back to jail. I'm unclear of the question.
Okay.
I'm
Did
just-
you, okay. What kind of things did you agree to when you made bond? What kind of behaviors and things did you agree to when you made bond?
Don't go anywhere that she may be.
Okay,
And I was not told where it is and went back to jail because of it. And, then, no illegal activity, I think, no, or whatever, just don't contact her.
okay. And other things like, appear for
I mean,
court.
there was a page. Yes, ma'am. There was a
There's a
page.
whole
I-
page of
I
different
have no,
things.
all that stuff was stolen. I don't know. It was all thrown in a dumpster.
Is this the only time you've ever made bond before in your life?
For this amount of time, yes, ma'am.
Okay. Have you ever had to go back for violating a bond condition before?
Yes, ma'am.
Okay, so you understand if you violate a bond condition, you go back to jail.
Yes.
All right,
Yes.
thank you.
Mr. Grants, without asking you the details, you were arrested in this case, if I understand correctly, on September 8th of 2024 for
Yes.
aggravated domestic assault.
Yes.
And you made mention that you were on an OR bond, but the file here
Oh.
says you made a $30,000 bond through Pardue Bonding Company.
Yes, sir.
Right. And
February was the OR.
That-
bond.
as of September the 8th of 2024, the bond conditions were that you must wear the GPS monitor. And that's since September the 8th of 2024,
Yes, sir.
you were
Yes, sir.
supposed to do that. All right. And then I have another indictment, and I'm not asking you about the details, but it is true, is it not, that you were charged in a separate case with committing crimes of theft on or about the possession of a stolen motorcycle, and that is alleged to have occurred on January the 8th of 2025.
Yes, sir.
And that's still pending.
As far as I know, yes, sir. Yes.
Thank you. Step down. Anything else
No,
you wish to be heard at argument?
I'll leave it up to the court.
Mr. Vaughn?
Briefly, Your Honor, it doesn't surprise me that an individual that has the public defender's office has struggles with financial issues. It's pretty much the common theme of each individual I represent. I am familiar with Mr. Krantz's situation somewhat through our discussions as far as, the house situation, I'm aware of what he does for a living as far as doing mechanic work. And they're kind of being, somewhat seasonal kind of work. It's hard to do mobile mechanic in when it's freezing. I think that his history shows that there was an effort being made. I think that he was legitimately doing the best he could. He has stated that he has a chunk that he can get caught back up to where he, by my estimate, $600 or $700 short from fully caught up. We would just like maybe some time to make some arrangements for that and allow Mr. Krantz to stay out on bond so he's able to assist me in his case.
Your Honor, we heard testimony from Ms. Anderson. There's been multiple attempts to try to bring the account current. If Mr. Krantz had the ability to pay that money, he would have paid it by this time. This is kind of the last resort when it comes to payments, as well as Mr. Krantz understands the conditions of being on bond. And if you're unable to meet a condition of bond, it is likely that you would return to jail. He has been arrested on new charges. He has also, we've had issues getting in contact with him on this motion. I believe this is the third setting, so I would be concerned he's not keeping good contact with the courts and his attorney, which is also a condition of bond. Therefore, I would say that he has violated his bond in that he is unable to maintain this monitor. He's been given multiple efforts to be outside and on bail pending the resolution of his case, and he has failed multiple times.
I think it's important to be aware of the fact that GPS monitoring devices are not required in every case where a person is makes bond. So the reason why, and this court was inquiring into the court file as to why it was necessary to impose the GPS monitoring device. And I find the following was set forth in the affidavit of complaint that originated in this case back on May the 31st of 2024. On that date, it states that on September the 8th, 2024, at 15:33 hours, Deputy Sutton was dispatched to twice daily on Jackson Felts in reference to an possible attempted murder. On arrival, contact was made with the victim, Alexandria Smith. She stated that prior to calling dispatch, she was at 1001 Carl Perry Road, behind the residence, arguing with her ex-boyfriend, the defendant, Jonathan Krantz, about her owing him $800 and stealing his phone. Victim stated that while they were arguing, the defendant had what was described as a black AR-15 style weapon in his hand. She stated that she sat down on the ground and began crying due to fear of being hurt by the defendant, advising that he had hit her with the gun in the past. The victim stated that while she was sitting on the ground, the defendant shot the firearm into the ground near where she was sitting. She stated her eyes were closed from crying when he shot and was unsure how close the round came to her. She described her right ear hurting after the shot. And that was the offense that led to the domestic aggravated assault charge being brought. On September the 8th of 2024, when he was arrested, the bond was set at $30,000 with a hand notation by the judicial commissioner, must wear a GPS monitor. That bond was made by Purdue Bonding Company, and it was also indicated that he would be required to adhere to the GPS monitoring devices as well. In the file, there was a prior instance of him having his motion in General Sessions Court, a motion being filed to revoke his bond. If I recall reading it correctly, that in the General Sessions, they sought to revoke his bond because he was out on a bond for aggravated domestic assault and that he had been arrested for tampering with his GPS monitoring by removing said device from his ankle. And they sought his bond to be revoked at that point. Obviously, I assume that didn't result in a revocation. But more importantly than his non-payment of those offenses, which certainly clearly violates the requirement of the GPS monitoring device, is the fact that on or about January the 8th of 2025, while he was on bond for this case, he was arrested and charged with possession of stolen property, a motorcycle. And that case is still pending. He has a 2-count indictment charging him with 2 counts of theft of property. One was a black 2022 black QLCG 50Z trailer, the other being a 2024 BMW S1R. And reading the affidavit, it does indicate that that he was found to be in possession of those vehicles. Pardon me. It came back stolen, Mr. Krantz. When those vehicles were checked, Mr. Krantz was in possession of the motorcycle. He admitted to borrowing the trailer, and when he got home, the motorcycle was inside. Anyway, the trailer was stolen out of Metro, and that was the reason that he was charged. So 4011-141 of the Tennessee Code states that subsection B, if after the defendant is released on personal recognizance on an unsecured personal appearance bond or other bond approved by the court, the defendant violates a condition of release, is charged with an offense committed during the defendant's release, or engages in conduct which results in the obstruction of the orderly and expeditious progress of the trial or other proceedings, then the court may revoke and terminate the defendant's bond and order the defendant held without bail pending trial or without release during trial. This court is of the opinion that all of those provisions apply to Mr. Krantz. One, he violated the condition of release by not only not paying for the GPS monitoring, but having had a prior instance where he attempted to remove the device or had it removed. And secondly, he is in fact been charged with a new offense committed while he was released on this bond. And then thirdly, he engaged in conduct resulting in the obstruction of orderly progress of this case by failing to appear in court and failing to stay in regular contact with his lawyer. For all of those reasons, the court finds that the bond should be revoked. Mr. Krantz is remanded to the custody of the Sheriff's Department pending trial. Mr. Krantz is in the custody of the Sheriff's Department. Morning, stuff. The inmates for 2 years. Go ahead and take up the inmates after Mr. Krantz is taken into custody. Mr. Krantz, you need to step back with the officer, please. No. Okay. We ready for any of the inmates? I'm ready to take up anybody that's ready.
Docket number 19733.
All right, Mr. Jerry Moore is charged with second-degree murder. Actually charged with 2 counts, but I think what is the status?
Your Honor, we're going to be entering a no contest plea to an count 1 that's going to be amended to second-degree, attempted second-degree murder, Class B felony. It's going to receive 8 years, split confinement, serve 1 year. He does have credit for time served. He has 278 days worth of credit. The sentence will be served at 85%. He is to stay away from the victim's family and the Dollar Generals in Cheatham County. And I do have his signature.
All right, Mr. Moore, raise your right hand. Let's place you under oath. Raise your right hand.
Yes, ma'am.
State your full name for the record.
Jerry Wayne Moore.
Mr. Moore, you're here today charged with 2 counts of second-degree murder involving the same individual under 2 different theories of responsibility. It's been indicated that you're going to be entering a plea of no contest to an amended charge of attempted second-degree murder, and receive a sentence of 8 years with split confinement, as your lawyer has stated. Have you seen or been shown a copy of the charges against you? Talked them over with your lawyer and discussed with your lawyer the range of punishments you're facing, as well as any possible defenses you might have.
Yes, sir.
Well, it's indicated that you want to enter a plea of no contendere or no contest. That simply means you understand what the state's evidence is going to be. You're not going to admit you did anything wrong, but you're not going to contest the state's evidence when they tell me what their evidence would be at trial. And that evidence will be used by me to find you guilty according to this agreement. Do you understand all that?
Yes, sir.
Do you understand, however, that you have a right to plead not guilty and to have a speedy and public trial by jury?
Yes, sir.
Do you understand that trial you would have the right to have a lawyer and to have one appointed if you cannot afford your own?
Yes, sir.
Do you understand if you went to trial, you would be presumed to be innocent until such time, if ever the state proved your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict would have to be unanimous before you could be convicted of anything?
Yes, sir.
You understand that if you went to trial, you and your lawyer could confront and cross-examine every witness the state called to testify against you, and you could bring in your own witnesses by the use of a subpoena.
Yes, sir.
You understand that if you went to trial, you would be presumed to be innocent. You would not have to testify or prove anything, and no inference of guilt would arise because you did not testify at your own trial.
Yes, sir.
You understand that if you went to trial and you were found guilty, you could appeal that conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal.
Yes, sir.
You understand that by pleading no contest, you are waiving your right to a trial and to an appeal. All I'm going to do is approve what your lawyer has worked out.
Yes, sir.
Do you understand that's going to result in a conviction? And that conviction will be on your record in the future to make more severe the punishment you receive if you're ever again convicted of a crime.
Yes, sir.
You understand everything I've explained to you?
Yes, sir.
Do you want to plead no contest to this charge according to this agreement?
Yes, sir.
Is your decision to plead no contest today voluntary?
Yes, sir.
Anybody forcing you to do this against your will?
No, sir.
Do you understand I cannot accept your plea unless I'm satisfied that you are guilty and there are facts to support it?
Yes, sir.
And I need you to listen as the state tells me what their evidence would be if this case went to trial.
Yes, Your Honor, docket 19733 on November 17th of 2022. Officers responded to 2621 Good Springs Road here in Ashland City, Tennessee, to a deceased person who turned out to be the victim in this case, a Terry Merritt Jr. Once the officers investigated, it was determined to be an overdose death. They did go through the victim's phone, found some contact with a female who said that her and the victim had went to purchase drugs from Mr. Moore. They spoke to him on speakerphone, and the purchase was for heroin, or what they thought was heroin. Once they went there, did get the drugs, and then brought them back home, and that's where the victim's father found him. Last saw him, I believe, at 5:30 in the morning, and found him unresponsive at home later on that afternoon. They did go and interview Mr. Moore. Mr. Moore did admit to knowing the victim as well as the female witness, and he did admit that, according to him, he had smoked methamphetamine with the victim, but he was pretty adamant about the fact that he had not sold him anything. So this is the negotiated plea. The victim's father is here, and he will at some point want to read a statement whenever the court's ready.
Mr. Moore, I'm not asking that you agree with those facts. Do you understand that's what the state's evidence would be if this case went to trial?
Yes, sir.
You still wish to plead this no contest to the amended charge?
Yes, sir.
You still wish to plead no contest?
Yes, sir.
All right. Are you satisfied with your attorney's services?
Yes, sir.
You believe your counsel has done a good job of representing you competently?
Yes, sir.
Do you know of any reason you should not enter this plea?
No, Your Honor.
All right. Then have a seat, Mr. Moore, if you will, and we're going to allow the victim's father to make the victim impact statement. You want to stand at the microphone there at the.
Thank you, Your Honor. I had to write it down, I forget. My son is Terry T. Merritt Jr. I am Terry Sr. I'm here with his mother, Vicky. She's back there. Not only did my 4 grandkids lose their dad, him and his mom are having a rough time without him. We love him dearly. Not only I lost my son, I lost my best friend. I don't know what's going to become
from this today, but I hope it keeps somebody else from going through what this family is going through. Losing a child is the worst thing ever. Thank you, Your Honor.
Thank you. Mr. Moore, come back to the stand. All right. Mr. Moore, upon your plea of no contest to the amended charge of attempted second-degree murder, I find you guilty, sentence you to 8 years Tennessee Department of Corrections, and will be served as split confinement for service of 1 year pursuant to statute with credit for time served. And pursuant to State versus Hicks, this will be an 85% release eligibility. He is ordered to stay away from the victim's family and all Dollar General stores in the state of Tennessee and Cheatham County. This is a situation where obviously there's been a life lost, and Mr. Moore has stated in his statement with the law enforcement that he didn't sell the drugs. But unfortunately, you're lucky to be alive too, whether or not you realize that or not. You know, people who ingest drugs, substances into their body without knowing what's in it are playing Russian roulette. And too often, especially in Cheatham County, it seems, we have deaths from overdose. We had a case not too long ago in front of me in this court where a man and his wife, young couple here in Cheatham County, wanted to celebrate their anniversary. So she said, I'll get a bottle of wine. Why don't you find us some drugs? So they were going to go get some cocaine. The husband went to buy the cocaine, bought it from some guy, came back. They found her dead in the house and him dead in the driveway. Both of them overdosed from fentanyl because they bought a bad batch of drugs. And, you know, there's no reason for them to have died. In this case, Mr. Moore, you were there when this all took place, and therefore you have some responsibility as according to this agreement. I understand this is probably a best interest situation as well, but I'm just saying this, you got 8 years to serve, and you're going to be on probation. Next time you think about putting something in your body or helping somebody else get drugs to put in their body, you might think about the fact you don't know what you're doing, and you might as well put a gun to your head and pull the trigger, because that's about as dangerous as you can get. So, all right, that's the judgment of the court. He'll be required to see the probation department after he's released from jail.
Yes, sir. Thank you.
Mr. Krantz. You want to put him on the 31st and give him a status day thereafter?
Let's do that. That sounds smart. I will be here.
We'll be here too.
He's not set. Is he set for trial?
I don't, not,
I don't think so.
When was it?
today. Today was, I believe, final plea from
We'll give
two.
him another final plea date of March 31st.
Thank you, Judge.
All right. What else do we need? Day versus Michael Deshaun Holt Jr. Let's see, we have somebody else in custody. Who else do we have over there?
Mario Castillo,
That is my final judgment.
All right.
docket 19748 and 19803.
So this involves two cases, Judge. 19748. Mr. Cosio's. He's pleading no contest to count 3, ag assault, C felony. That's 6 years TDOC suspended to supervised probation after serving 6 months, credit for time served. He's been incarcerated since September 30th of 2025. And at today's date, it's my calculation that he's got 161 days out of 180, so he is close. And then in case number 19803, he is pleading to resisting arrest, 6 months concurrent, But of course, this time of year is, you know, that. So.
All right. Mr. Castillo, raise your right hand.
I do.
State your full name for the record.
So Mario Trinidad Castillo.
You are here today charged with several different offenses, but have you seen or been shown a copy of those charges, talked them over with your lawyer, and discussed the range of punishments you're facing as well as any possible defenses you might have?
Yes, Your Honor.
Well, it's indicated that you want to enter a plea of no contest or nolo contendere. All that means is you understand what you're charged with. You understand what the state's evidence is. You're not going to admit you did anything wrong, but you're not going to contest the state's evidence when they tell me what their evidence would be at trial. And I will use that evidence to find you guilty according to this agreement. Do you understand that?
Yes, Your Honor.
Do you understand, however, that you have a right to plead not guilty to all charges and have a speedy and public trial by jury?
Yes, Your Honor.
Do you understand that if you went to trial, you would have the right to have an attorney and to have one appointed if you cannot afford one? And we've done that with a public defender.
Yes, Your Honor.
Do you understand at trial, you'd be presumed to be innocent until such time, if ever the state proved your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict would have to be unanimous before you could be convicted of anything?
Yes, Your Honor.
Do you understand that if you went to trial, you and Mr. Vaughn could confront and cross-examine every witness the state called to testify against you, and you could bring in your own witnesses by the use of a subpoena?
Yes, Your Honor.
Do you understand that if you went to trial, you'd be presumed to be innocent? You would not have to testify or prove anything, and no inference of guilt would arise because you did not testify at your own trial.
Yes, Your Honor.
Do you understand that if you went to trial and you were found guilty, you could appeal that conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal?
Yes, Your Honor.
Do you understand that by entering this plea of no contest, you're waiving your right to a trial and to an appeal? All I'm going to do is approve what your lawyer and the state have agreed upon.
Yes, Your Honor.
But you understand that's going to result in 2 convictions, and those convictions are going to be on your record in the future to make more severe the punishments you receive if you're ever again convicted of a crime.
Yes, Your Honor.
Do you understand everything I've explained to you?
Yes, Your Honor.
Do you want to plead no contest according to this agreement and waive your right to a trial and to an appeal?
I do. Yes, Your Honor.
Is your decision to plead no contest today voluntary?
Yes, Your Honor.
Anybody forcing you to do this against your will?
No, Your Honor.
Do you understand I cannot accept your plea unless I'm satisfied there is a factual basis for it and that you are in fact guilty?
Yes, Your Honor.
Then listen as the state tells me what their evidence would be if this case went to trial.
First, in docket 19748, officers responded on May the 20th, 2025 to 1100 Buckstorm Road here in Cheatham County, Tennessee, to report of shots fired. Once the investigation was completed, it was determined that the neighbors and the victims of Mr. Cosio, the male, Mr. Wilson, had went over to his home to retrieve some tree straps. He thought he had permission to be on the property. Mr. Cosio, if he had permission, he didn't that day, and he asked him to leave. As he was leaving, Mr. Wilson would testify that he fired 3 shots as he was walking away. When officers arrived and Mirandized Mr. Cosio, he did admit to shooting him, but he claimed that Mr. Wilson had a machete or some sort of weapon on his person. Those would be the facts in 19748. In 19803, on the date listed in the indictment, while this case was pending, Mr. Cosio went to the Cheatham County Sheriff's Office. He was demanding or seeking to get some videos and body camera from the May 20th incident. And when they told him and explained to him that his Freedom of Information request did not include pending investigations, he became irate, started cursing at them. They asked him to leave the property or at least the room. They did get him out of the front office. And when he was outside, continued to yell. And I believe Lieutenant Dunning would state that he hit the door, and at that point, he was placed under arrest for disorderly conduct, and he resisted that arrest.
I'm not asking you to agree with those facts, but do you understand that's what the state's evidence would be at trial?
Yes, Your Honor.
Are you satisfied with your attorney services?
Yes, Your Honor.
I feel like that Mr. Vaughn has done a good job of representing you competently.
Yes, Your Honor.
Mr. Vaughn, you know of any reason you should not enter this plea?
Can you repeat that?
I'm asking Mr. Vaughn if he knows of any reason you should not enter this plea. Then Mario Casio in docket number 19748, upon your plea of no contest, I find you guilty of aggravated assault. sent you to 6 years Tennessee Department of Corrections that will be suspended to supervised probation after you serve 6 months with credit for time served. You're to have no contact with the victim and pay $60 restitution to the victim. Docket number 19803, you're found guilty of resisting arrest, sentenced to 6 months in the county jail with credit for time served, and all of the counts and all of their indictments are dismissed as a part of this agreement. Thank you.
I will say, just to reiterate this, Your Honor, I don't know if the Wilsons still live next door, but any hint I get of contact, we'll get a violation warrant, and Mr. Cosio will hopefully be right back.
Obviously, that's part of the agreement on the suspended sentences to be no contact with the victim, so you need to be very careful about that. So,
Yes, sir. Thank you.
all right, thank you. We have one more inmate.
Hey. Docket number 19628.
Judge, Mr. Haney is also mine. It's one of those that, was from the Ice Storm Times BOP day. I put him on today's docket. He's going to admit that he's in violation, and be reinstated to probation with the credit for time he's been sitting and serving.
All right, so he's going to be admitting violation of probation, be reinstated to probation, and anything else?
No, Judge, that's it.
Mr. Haney, raise your right hand. Let's place you under oath.
Yes, ma'am.
State your full name for the record.
Michael Haney.
Mr. Haney, you're here charged with violation of probation. Do you understand you have a right to plead not guilty and to have a hearing in this court where the state would be required to prove to the legal standards you had violated your probation?
Yes, sir.
You understand that you would have the right to have a lawyer and to have one appointed if you cannot afford your own?
Yes, sir.
You understand if we had that hearing and I found you guilty, you could appeal whatever I did in your case to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal?
Yes, sir.
You understand that by entering this plea, you're waiving your right to that hearing and that appeal. All I'm going to do is approve what your lawyer and the state have agreed upon.
Yes, sir.
That's going to reinstate you to probation. You understand that?
Yes.
Do you understand everything I've explained to you?
Yes, sir.
Do you want to enter a plea of guilty according to this agreement?
Yes, sir.
And upon your plea of guilty, I find you guilty. In order that you be revoked to serve your sentence, but by agreement with the state and on time served, I will order that you be reinstated to probation. Thank you. You'll need to continue reporting to the probation office.
Thank you.
All right, thank you.
We still have Mr. Richardson, who's not appeared for his arraignment. He had called the court earlier today and said that he was sick. I also have filed a motion to revoke his bond. Reason being, and I heard the court say that if he comes in to wear a mask, Mr. Richardson's sick is not the catching kind. Mr. Richardson wears a scram device. He has had multiple alerts that he has a BAC sometimes at
Benjamin Parker
0.24.
Richardson, are you ready then to proceed on that? Is he represented?
He is not represented and he hasn't appeared today. So I do know that his sickness may not be.
Conditional forfeiture of his bond, capious for his arrest.
Thank you, Your Honor.
All right. We know what. Well, doesn't matter. Be a citation for the bonding company issue that and set it for the September date for final hearing. His new bond will be held for hearing. Anybody have anything else? Speak now or forever hold your peace.
I believe I do.
There's somebody in the back.
Yeah, I've not heard this guy.
Come on up. What happened to Mr. Takovas? Lucky him. Well, up here. What's your name?
Jacoby.
Cody?
Jacoby.
Quijada.
Quijada.
Is that the one? Oh, we've got the 130.
Oh, is this the one I'm supposed to stand in for Marion?
That's not Mr. Harrison.
Oh, okay.
Jacoby, right?
Yes, ma'am.
No, that's not it. What we have at 1 o'clock, Mr. Vaughn, I think what we had was the Harrison case that you're standing in for, Miss,
I haven't heard anything from Marion.
but it was, you understood what the agreement was on the sentence?
I do.
And he's supposed to be here at 1. So
That's what I was told.
we will resume at 1 o'clock and hopefully have,
Do I need to be here for that, or can we just say?
I don't have a problem with you just announcing what the agreement is as to the sentence.
Okay.
Mr. Vaughn has some animals he needs to go kick.
Yes.
Take your dogs, Judge.
Make sure there's no trespassers.
Yeah,
Keep the fortress safe. Release that.
we had a Michael Deshaun Holt that had a no answer also. It was for arraignment and evading arrest.
Yes, and I had filed to revoke his bond based on another arrest in Clarksville, but I obviously didn't serve that on his attorney yet because he didn't have one.
We have a $20,750 bond, be a conditional forfeiture of his bond. I'm going to do a conditional forfeiture until we can get him in here to have that hearing. Conditional forfeiture of his bond, capious for his arrest. New bond will be set at $100,000.
I think he mostly hangs out in Clarksville, so I'll let the officers know.
Except for, sorry, the final forfeiture will be set for that September date. All right, so that leaves us. Yes, it was just a mess.
A routine court session took a dramatic turn when a defendant facing a 17-count animal cruelty indictment appeared before the judge seeking court-appointed counsel. The defendant argued that she could not afford an attorney, and after reviewing her financial situation, the judge found that she qualified as indigent and appointed a public defender to represent her. But the hearing quickly became tense when the defendant began objecting to the attorney assignment and attempted to choose a different lawyer. That's when the judge delivered a firm reminder. If the court is appointing counsel, the defendant does not get to handpick who that attorney will be. The judge made it clear that appointed lawyers are assigned based on legal requirements, not personal preference. The discussion then shifted to the heart of the case. Prosecutors explained that the defendant was facing a large indictment involving animals that had been removed from her property. The court scheduled a future hearing to determine whether a bond would be required to cover the ongoing cost of caring for those animals while the criminal case remained pending. The judge carefully explained that if the required bond was not posted, the animals could legally be considered abandoned under state law. The defendant repeatedly interrupted and argued about legal representation, but the judge remained firm and repeatedly explained the difference between the criminal case and the related civil proceedings. Later in the session, another defendant appeared before the court on serious drug and weapons charges. Prosecutors alleged that officers discovered mushrooms intended for resale, marijuana, THC products, drug paraphernalia, thousands of dollars in cash, and a firearm during a traffic stop. After reviewing his constitutional rights, the defendant chose to waive grand jury proceedings and plead guilty under a negotiated agreement. The judge carefully questioned him to ensure he understood every consequence of the plea before accepting it and imposing a multi-year probationary sentence. The courtroom saw several other guilty pleas throughout the day, including assault and felony-related cases. But the biggest message from the hearing remained the same. Whether facing animal cruelty allegations, drug charges, or violent offenses, the court expects accountability, respect for the legal process, and a full understanding of the consequences that come with every decision made inside the courtroom. Do you think defendants should be allowed to choose their court-appointed attorneys, or should judges make that decision?